ago, this month, the Oversight and Investigation Subcommittee hearing had testimony from the chairman of the Federal Deposit Insurance Corporation on its role in Operation Choke Point, which is a law enforcement initiative launched by the Department of Justice to choke off legal businesses from the financial system in an effort, per they say, to combat consumer fraud. Although the FDIC has repeatedly denied that it was involved in the DOJ-named Operation Choke Point, it is clear from the investigative work of this committee and other committees that the FDIC cooperated closely with the DOJ in identifying so-called high-risk merchants and sever their ties with the financial system through its supervisory authority. Payday lenders, gun dealers, and other perfectly legal industries were targeted by the FDIC based on the corporation's own decision about which industries were favorable and which industries were unfavorable. Regrettably, we are here today to learn about a separate but no less egregious effort by the FDIC to target Refund Anticipation Loans, or RALs, which simply put are loans based on anticipated federal tax refunds. A recent Inspector General report of inquiry into the FDIC's supervisory approach to refund anticipation loans reveals a troubling pattern by the FDIC officials of targeting legitimate and legal activities through abusive and unfair regulatory practices. The IG uncovered this targeting when performing its audit on the FDIC's involvement in the Operation Choke Point initiative, which was released in September of 2015. Although only an executive summary of this extensive 180-page report of inquiry is being made public, I'm concerned because the full report details actions of several FDIC employees who were also involved in the Operation Choke Point initiative. According to the Inspector General, the FDIC, quote, set in motion a series of interrelated events affecting 3 institutions that involved aggressive and unprecedented efforts to use the FDIC's supervisory and enforcement powers, circumvention of certain controls surrounding the exercise of enforcement power, damage to the morale of certain field examination staff, and high cost to the 3 impacted institutions, end quote. In an effort to cause the 3 banks it supervised to exit the RAL business, the FDIC's Washington office also used, quote, strong moral suasion, end quote, in late 2009 and early 2010. The FDIC also used its powers to inappropriately reject underwriting plans and pressure field staff to assign lower ratings in safety and soundness examinations for at least 2 of the institutions, and used unprecedented examination resources to conduct an intrusive horizontal review when one bank continued offering RALs. The Inspector General's report also found that the FDIC's legal division believed the pursuit of such enforcement remedies against the banks represented high litigation risk, but the agency proceeded anyway. All 3 banks ultimately, no surprise, exited the RAL business by April of 2012. After the FDIC Chairman Sheila Bair asked management to look into a complaint made by one of these targeted institutions, FDIC management did not accurately and fully describe the abusive behavior to Chairman Bair. This kind of behavior cannot and will not be tolerated by Congress and the American people, who expect much more from their government and their government bureaucrats. I'm concerned that the FDIC has repeatedly demonstrated a disregard for the rule of law, for the limitations of its power, and for the financial institutions that it is supposed to serve. The work of this subcommittee is an important way to hold the corporation accountable and to expose its behavior to ensure that it is kept in check. That concludes my remarks, and I'll now recognize the ranking